Well, hello everyone. My name is Ryan Dyer. I'm an attorney here at Beresford Booth, and today's webinar is going to be about insurance disputes, or primarily just Insurance 101. So I appreciate everyone taking the time to be here and check this out today. Let's get right into it. So this will be very introductory. I'm not going to be getting too deep into the weeds on things. It's definitely a 30,000 foot view. And a little disclaimer, this is not legal advice. Please don't take it as legal advice in any way. I'm just kind of outlining some basic things that might help folks out. Another thing to talk about is that insurance law, there are some similarities across the country, but it really is state by state specific. And what I mean by that is each state has its own substantive law and statutes that really dictate how insurance companies can operate and the sort of interplay between insurance carriers and their insured or policyholders. So today's presentation is mostly tethered to Washington state law on this. And if you're in another jurisdiction or if you have a policy that was issued in another state, you may need to reference the differences in that state's laws and statutes because they may be different from Washington state. Finally, we're going to be mainly the sort of policies that my presentation today are really going to be focused on is going to be the standard stuff potential clients or folks deal with either personally or with their businesses. And those are typically homeowners insurance policies, title insurance policies, or commercial general liability policies that you might have for a small business or LLC, or if you're a landlord, perhaps you might have a CGL policy or something like that. We won't be covering auto policies, underinsured motorist stuff. There is some crossover, but those are kind of their own animal and require a little bit different analysis. So here's what we are focusing on, though, more specifically. I'm going to just describe the basic mechanics of how your typical kind of generic insurance policy works. We're going to touch briefly on, the importance of submitting a notice of claim or potential claim to your insurance carrier. We're going to talk about the sort of correspondence that goes back and forth with an adjuster at the outset once you have submitted that notice of claim or a potential claim. And then we're going to talk about, what the potential legal remedies could be if you feel like your insurance carrier is jerking your chain or has denied coverage and you feel like that's improper, or if they're just kind of kicking the can down the road and not stepping up to the plate. We'll talk about some of the legal remedies that could be available to you. But first, I want to touch on something that's very, very important. I call it the 10 commandments of being a policyholder or being an insured, meaning someone who has a policy of insurance issued to them. They're pretty simple. I think you're all going to remember them. But the very first thing you should always do as a potential policyholder even is to read the policy that you're about to buy. And obviously that's commandment 1 through 10. Read your policy. I know they can be very long and they can appear dense, but the fact of the matter is that most insurance policies in any context that you're going to be dealing with typically are usually written in plain English. They're not using, big convoluted language or words. They're just using a lot of simple plain English. So it's more of a quantity that you have to read than a complexity. But in any case, read your policy before you get it, read it after you've signed it. That'll give you a sense of orientation around what is or isn't covered. That'll really help you out, especially after you listen to my presentation. You may identify things in your policy that are not present that I'm going to touch on here. So read your policy, folks. Rule number 1 through 10. Okay, so the basic mechanics, and everyone's pretty aware of this. Like I said at the beginning, this is very introductory, more of a primer for many folks. We'll get into some more complicated things later. But look, you're paying, normally you're getting an insurance policy on an annual basis. and you're paying an annual premium in exchange for a certain degree of coverage for yourself. Now, there are policies that may have 2-year policy periods. They may have less than that or more than that, but the typical policy is annual. And a lot of times you can either pay that annual premium all at once, in which case you might even get a discount, or you pay it monthly, which a lot of folks do as well. So you're paying a premium, and in exchange for that money, you're getting coverage. And the coverage usually falls into 3 categories. You're getting coverage for losses or damages you might sustain. For example, if you have a homeowner's policy and you have a loss, lightning strikes and sets fire to your roof, that would be the loss or the damage that's covered under your homeowner's policy. A lot of times you're also paying for liability coverage, meaning, for example, in the homeowner's context, if someone slips or say you have a loose step and they slip on that step and injure themselves, you would potentially be liable to them for their damages if they can prove that you were negligent. And so you're getting coverage for liability that would arise out of that. That's obviously the main thing you're getting in a commercial general liability policy as well, is coverage for anything you might be liable for. Now, there's a special caveat here on liability, and that's that you can really only get coverage for accidents that cause a liability. Negligence is the best example of that. So, if you have a loose step or something in your house that's a defective and somebody gets injured because of that, well, that is an accident. Even if you knew that particular component of your home maybe wasn't perfect, you didn't intend for that person to injure themselves. The flip side of that, to help you understand, would be that there's no such thing as getting coverage for illegal or intentional acts. Very few caveats to that. That's virtually a universal rule, is that, for example, if someone's invited into your home and they say something nasty about you and you punch them right in the face and they break their nose, well, you're not getting coverage for the liability that you might owe that person for breaking their nose, even if they are a jerk. That's simply not covered. So you're covered for accidents, not for intentional or criminal acts that you or another person covered under your policy may commit. Finally, and this is a huge one, especially for folks who don't have a lot of insurance or legal background, is that quite often your insurance policy, whether that is a homeowner's policy, a title insurance policy, or a liability policy, it covers your legal costs. That is huge for many folks. For example, if someone gets injured at your home and their injuries may be, say, $50,000 and they decide to file a lawsuit against you, well, in a lot of cases, your legal fees alone are going to be far larger or at least the same as the actual liability or loss that occurred. So that's something to keep in mind in so many contexts, is that when you have a loss or a liability that arises against you, not only does your insurance often cover the actual loss or liability, it actually covers the legal costs that arise from that. Again, read your policy, but that is quite often the case. And I'll do you one better, folks. A lot of times the coverage for your legal defense fees and attorney costs is uncapped. Now, this will depend on the policy, but what that means is say you have a homeowner's policy with $500,000 in liability coverage, your potential legal cost coverage or cost of defense coverage could be in excess of that theoretically, which is quite frankly one of the biggest things you're paying for with your premium, is the legal coverage aspect of your insurance policy. So those are really basic mechanics. I'm going to move right along here, and let's talk about what we mean by coverage. So virtually any policy, it basically, you get coverage for a covered event, which is often termed an occurrence. in the policy language. So as you read your policy, you may see some sort of language in there that says, we cover occurrences, and occurrences are these things. A common one is a casualty, and that's just a fancy word of a property loss or some sort of damage that was caused. That is a casualty occurrence. Another one is occurrence against liability against you or claims against you. Now, this is another tricky one, and it's going to depend on your policy, but usually, in many contexts, a claim against you doesn't become an occurrence until there's actually a lawsuit filed. Now, that like I said, that is complicated and can depend on the policy and the circumstances. So you may need to seek some clarification there, but claims against you can be an occurrence under your policy, and quite often what the insurance carrier wants to see is that an actual claim has been filed against you. So that would be another example of an occurrence. In the context of title insurance, an occurrence can be when there is some sort of challenge to your title or your interest in your real estate. So the very generic example is you buy a piece of real property, you buy a new home for yourself, or you buy some real property to be an asset in your business. You get title insurance to basically protect your ownership of that. And your title carrier is saying, look, we're willing to ensure that John Doe owns this property that he just bought. And if someone turns up and says, actually, I own that property, either I own the whole thing or I own part of it, but you, John Doe, don't actually own it. Well, that's an example of a challenge to your title or interest in real property that would be provided by a typical generic title insurance policy. So that's what we mean by covered events, covered occurrences, covered claims or challenges. Now, triggering coverage. Theoretically, your insurance says it's going to cover these sorts of things, but it doesn't actually become triggered until you submit notice of a claim, which is often called a tender. And tender is just the verb for submitting your claim or notice of a claim to your carrier to trigger your coverage. Couple things to keep in mind here. Note your notice of a claim or your tender of a claim, it has to be reasonably timely. In other words, if you get sued, for example, you probably should tell your carrier about it pretty quickly. And quite frankly, the best practice is that if you're aware that someone is about to sue you or someone is making a claim, you should probably go ahead and notify your carrier of that immediately. Back to our homeowners example. If you're having a birthday party at your property, somebody slips on something and injures themselves, and I would suggest maybe letting your carrier know about that as soon as possible. Even before the dust settles and you realize what the extent of the injuries were or whether this person blames you, let your carrier know. You can't be too early, quite frankly, in notifying your carrier of a claim or potential claim or loss under your policy. Another good example would be a homeowner's policy. If you have some sort of damage to your property or loss at your property that you believe is covered, go ahead and let your carrier know about it right away, right after that lightning storm, right after that water loss or fire. Let your carrier know. Now, the reason this is important is because an insurance carrier has the potential to challenge coverage if they can prove that the notice they received or the tender was unreasonably timed. Now, I put down here good luck because the carrier does have to show actual prejudice, but quite frankly, if you wait too long, they could raise this challenge to coverage. In which case, give me a call and give me or someone else a call and we can talk about whether or not you're in real trouble or whether this is just the insurance carrier posturing towards you a little bit. But best practice, submit your notice of claim or your tender really quickly. Okay, let's talk about corresponding with your insurance carrier. Your correspondence, once you submit or tender a claim, you're going to be assigned what's called an adjuster. That's different than your insurance broker, whomever sold you the policy. The adjuster is the adjusting divisions within an insurance company. Those are the folks who handle and evaluate claims as they come in. And that's typically going to be someone assigned to you. There will be a policy uh, excuse me, there will be a essentially someone who's assigned, and a claim number will be generated for you, and from there you kind of that'll be the claim number that your policy's handled under with an adjuster. Now I put right up here, if it ain't in writing, it never happened. Now that's a little bit tongue in cheek, but it's important when you're corresponding with your adjuster or your insurance carrier about a claim or tender that you try to do it in writing. Okay. Everything should be in writing. That way there's a clear record of the information being passed. I know a lot of folks find it more convenient and efficient just to have phone conversations, but there's, especially when you're dealing with a big loss or something that you're uncomfortable with, try to make sure everything's in writing. You're often going to be asked to provide information to your carrier, and in fact, you have a duty to do that, to make sure you provide all available information to your carrier. That being said, if you feel like you don't know what your carrier wants, be very specific. A lot of times adjusters will say, send me all relevant information about your claim. Okay, well, for a lot of lay people, it may not be obvious what all relevant information about their claim is. And so don't be afraid to specifically ask your adjuster, can you tell me exactly what sort of information you need? And they'll do that. One thing that I say, although I don't want to give folks a false negative view, is some adjusters would rather just talk to you over the phone and interview you in that way. Like I said, that may seem efficient, but you really want to generate that written record, because let me put it this way: once you get off the phone with your adjuster, they're making a note of how that conversation went. And if you don't put things in writing, that adjuster's log note or whatever they have entered in their file is going to be the only written record of that conversation. And if it's inaccurate, or if you think it's unfair, it can be difficult to overcome that written record down the road. So, if you do talk to your adjuster on the phone, or they want to interview you briefly, make sure you send a follow-up email to them summarizing what you remember being discussed. Now, let's talk about some specific sort of four kind of specific things that can happen once you've tendered. And I apologize, this isn't broken out, but the first one is that your adjuster will accept your claim and unilaterally tell you in writing that your carrier is going to accept the claim and provide the coverage, whatever that may be, for the loss or occurrence. Another one that can often happen is that there will be a deferral of the claim and or a request for additional information. And a good example of this would be the sort of situation I talked about earlier, where you've submitted someone is telling you they're going to sue you, or they're sending you letters saying that they believe you owe them monetary damages for some reason, but they haven't filed the lawsuit yet. And basically, you'll tender to your carrier, and they'll say, okay, thank you for the notice. Let us know when you get sued. And that's when we'll make some sort of coverage determination. So that can be the second sort of correspondence you get back from your carrier once you've tendered. A third one is a reservation of rights. And you see my little, I'll call it ambivalent face with this one. Basically, what your carrier is saying is that, okay, we're going to go ahead and extend coverage for now, but we're going to reserve our rights to withdraw coverage if we find out through our investigation that this loss actually isn't a covered occurrence or event under your policy. And so, that's kind of helpful, because they are accepting some form of coverage on your behalf. But beware, because that reservation of rights letter will typically have a lot of language in it telling you why and how your carrier may eventually deny coverage and essentially pull the rug out from under you. So you get a reservation of rights letter back, give us a call. That might be worth getting some legal advice on what that means. And then finally, the worst thing you can get is just a flat denial of your claim. And usually that won't be hard to interpret. The letter you'll get back, or the correspondence you'll get back, will say your claim has been denied. And then they'll provide you an explanation why. So those are kind of the four sorts of responses you can get back from your insurance carrier once you've tendered or made a claim. Now, let's assume this really applies a lot to when you have liability coverage, or when you have the sort of coverage that includes legal expenses that you might incur for a loss or occurrence. I want to really kind of touch on how that works. And so in a lot of cases, let's use the slip and fall at your home, at your birthday party at your house example. Your insurance company will either do a reservation of rights or they'll accept the claim. And what they'll do is they will typically appoint a defense lawyer to defend you. Now, these defense lawyers, well, let me get to that in a minute. And so that coverage is different than the actual coverage for the loss. And a common way you'll hear of this broken down is there's a duty to defend and a duty to cover. Now, the duty to defend you is much broader than the actual duty to cover. And let me approach that in reverse. Your insurance carrier's duty to cover losses is entirely dependent on the policy language. In other words, it's kind of either yes or no. There's coverage or there isn't. However, your insurance company's duty to defend you, if it exists, is very broad, especially under Washington law. And essentially what that means is that they have to cover you if there's a reasonable possibility that the loss or occurrence falls within the coverage scope. In other words, you don't have to have a determination that the loss or occurrence or liability is actually covered. If it's possible it's covered, your insurance carrier has to defend you unless and until it is clearly established that the loss is not covered, and then they can pull their coverage. So be mindful of that distinction. But let's return to if they've decided to defend you, they've appointed an insurance defense lawyer on your behalf. Now, that insurance lawyer has a dual duty that I think any policyholder should be aware of. Obviously, they have a fiduciary duty to you as a client. They are representing you in the lawsuit as your lawyer. However, they also have a reporting duty to your insurance carrier. In other words, they're telling your insurance carrier everything that's happening in the case, including their evaluations of the nature of the loss and so forth, which your insurance carrier may use to make further determinations as to whether you're actually covered. So always be mindful of that. I'm not trying to throw any shade here. The vast majority of insurance defense lawyers put their client, the insured policyholder's interests first, but you should be aware that they are reporting to your insurance carrier about how their work is going on your behalf, and that your insurance carrier is using that information to decide whether or not they're going to continue extending coverage in the particular instance. Now, some common examples of potential conflicts. I just went over covered versus uncovered claims. One thing to remember is that if someone slips and falls at your home, for example, that would typically be covered under your homeowner's policy. However, they might sue you, and in their lawsuit, they might say two things. They might say, I slipped and fall because John Doe doesn't, repair his steps on his deck. Or they could, and then they could also say in the same complaint, the same legal lawsuit, in the alternative, I think John Doe pushed me off those stairs, and that's why I fell. So obviously that would be an intentional tort. So if you're getting sued for a situation where they're alleging both a covered event and an uncovered event, your insurance carrier typically has to defend you for both. They can't just try to say, we're only going to cover you for this allegation, but not that. They have to cover you for both. However, if there may be a lot of situations where you have a counterclaim or against that person who's suing you, or you have a third-party claim, meaning you would say, okay, this person slipped and fell on my faulty step, but I think I need to sue the contractor who installed that deck last month because they installed it incorrectly. Now, your insurance carrier may not cover the legal work required to bring that counterclaim or that third-party claim, and they might have an ability to insist that you hire a separate lawyer to handle that aspect of your lawsuit. So be aware of that. And another big one that I want everyone to remember is that Your insurance company typically has a duty to settle within policy limits. This one's important. Someone slips and falls on your deck, they sue you, you have $250,000 insurance, but they broke their neck. They need, they think they need $300,000, $400,000, $500,000 of damages from you. Your insurance company really shouldn't joke around with that, meaning if they get what's called a limits demand from the plaintiff in that lawsuit, and they have the ability to settle your claim for your policy limits, they have to do that. If they don't do that, and you're subsequently subject to a judgment in excess of your insurance coverage, you may have a claim against your carrier for breaching its duty to settle, in which case your carrier could be liable to pay not only their policy limits, but whatever your liability was above and beyond your policy limits. I want to talk a little bit about what to do if your insurance company does wrong by you, essentially. And the big thing we're going to talk about is the Washington Insurance Fair Conduct Act under RCW 4830. We're also going to touch on some common law bad faith very briefly. So in order to have an IFCA claim, your insurance carrier has to unreasonably deny your coverage. That's the trigger. There needs to be a denial. They can't just keep kicking you down the road. They actually have to deny. But once they do, there's several other things that can happen. There's several no-nos once they've denied that can trigger even more liability. And that's if they fail to complete their investigation within 30 days without good cause, if they refuse to play, if they basically deny your claim without conducting any reasonable investigation, if they deny your claim basically wrongfully, or don't otherwise tell you what the exclusion is that they're denying it under. And it also, other timing things. If they just don't give you a reasonable explanation within a certain amount of time about why you've been complied. And then fifth, and this kind of goes to my duty to settle point, if they basically, expose you to some sort of liability without paying the claim for substantially less than what it could have been, could also be bad faith. So IFCA is very powerful. If you win on IFCA, you get your actual damages, which would be the economic loss and your non-economic loss. So you could potentially get things like pain and suffering, the time you had to take away from other things to deal with all of this and so forth. The two other big things is you would get your attorney's fees and costs you incurred in having to hire an attorney to litigate the coverage against your carrier. So you'd be entitled to get those. And finally, the big one is that you could get treble damages, meaning triple your actual damages. And basically, this is there to provide an incentive for insurance companies not to fool around with this. Finally, Washington does also have a common law bad faith basis to sue your insurance company for wrongfully denying your claims. In that case, though, there is no treble damages, but there are attorney's fees and actual damages. So a lot of times what will happen is that, if you come into us for a consultation and we believe you have a basis to bring a lawsuit against your carrier, you'll bring both an IFCA claim and a common law bad faith claim in tandem. They do overlap quite a bit, but they're both kind of separate animals and separate ways to sue your insurance company. So, that's it. Like I said, I wanted this to be very brief and just give everyone a primer here. If you have any questions, again, my name is Ryan Dyer. You can reach me at ryand@beresfordlaw.com, or you can call anytime for a consultation at 425-776-4100. Again, don't remember the 10 commandments of insurance policy or being a policy holder, and that's read your policy, folks. That'll be very helpful to you. So with that, I'll let everyone get along with their day, and thank you very much for listening.